Question 1. In California, which authority is primarily responsible for issuing a concealed handgun license, CHL, also known as a CCW permit? A. The California Department of Justice, DOJ. B. The local county sheriff or chief of police of an incorporated city. C. The California Highway Patrol, CHP. D. The Department of Motor Vehicles, DMV. Answer: B. The local county sheriff or chief of police of an incorporated city. In California, the authority to issue a concealed handgun license, CHL, is vested in the local county sheriff for residents of the county, or the chief of police for residents within an incorporated city. This means your application goes to your specific local law enforcement agency, not a state-level department like the DOJ or CHP. Obtaining a CCW permit is a local process, so contact your county sheriff's department or city police department for their specific application procedures. Question 2. Under California law, which of the following is generally considered a sensitive place, where carrying a concealed firearm is prohibited, even with a valid CCW license? A. A privately owned retail store that does not display "No Firearms" signs. B. A public park or recreation area. C. A public library or other public building used for public meetings. D. Your personal vehicle parked on a public street. Answer: C. A public library or other public building used for public meetings. California law designates numerous sensitive places where carrying a concealed firearm is prohibited, even with a valid CCW license. These places often include government buildings, schools, polling places, and, as of recent legislative updates, many public buildings like libraries or those used for public meetings. It's critical to be aware of these restricted zones to ensure compliance and avoid severe legal penalties. Always review the most current list of prohibited sensitive places specific to California. Question 3. What is the fundamental principle of self-defense regarding the use of a firearm in California? A. You can use a firearm anytime you feel threatened. B. You can use a firearm only if there is an immediate threat of death or great bodily injury, and your actions are reasonable and necessary. C. You can use a firearm to protect your property from theft. D. You can use a firearm to prevent someone from fleeing after committing a crime. Answer: B. You can use a firearm only if there is an immediate threat of death or great bodily injury, and your actions are reasonable and necessary. In California, the use of a firearm in self-defense is only legally justified when there is an immediate threat of death or great bodily injury to yourself or another person, and the force used is both reasonable and necessary to counter that threat. This principle emphasizes that lethal force is a last resort and must be proportionate to the danger faced. Remember, the law does not permit the use of deadly force to protect property alone or to prevent someone from escaping after a crime. Question 4. If you are carrying a concealed firearm with a valid California CCW permit and are stopped by law enforcement, what is generally the best course of action? A. Remain silent and do not mention your firearm unless directly asked. B. Immediately announce you are carrying a firearm and reach for your identification and permit. C. Declare you have a CCW permit and are carrying a firearm, then follow all instructions from the officer. D. Hand over your firearm to the officer immediately for safekeeping during the stop. Answer: C. Declare you have a CCW permit and are carrying a firearm, then follow all instructions from the officer. When stopped by law enforcement while lawfully carrying a concealed firearm, it is generally recommended and often a condition of your permit to immediately and clearly inform the officer that you possess a concealed handgun license and are carrying a firearm. After declaring, keep your hands visible and follow all instructions precisely, such as not reaching for your firearm or permit until directed. This open communication ensures officer safety and minimizes potential misunderstandings. Question 5. Which of the following is a common requirement for obtaining a California Concealed Handgun License, CCW? A. Proof of ownership of multiple firearms. B. Completing a minimum of 16 hours of firearms training. C. Demonstrating a specific, good cause for carrying a firearm, such as protecting large sums of money. D. Being a current or retired law enforcement officer. Answer: B. Completing a minimum of 16 hours of firearms training. A common requirement for obtaining a California Concealed Handgun License, CCW, is completing a minimum of 16 hours of approved firearms training. This training typically includes instruction on firearm safety, the legal aspects of firearm use, and qualification on the range with the specific firearms listed on the permit. While good cause was a previous requirement, post-Bruin, the focus has shifted to demonstrating good moral character and completing comprehensive training, ensuring applicants are proficient and responsible. Question 6. When a CCW permit holder is not actively carrying their firearm, how must it generally be stored if a minor could access it? A. Hidden under a bed or in an unlocked drawer. B. Stored in a locked container or disabled with a trigger lock, rendering it inaccessible to a minor. C. Unloaded and kept separate from ammunition. D. Stored in the original manufacturer's case. Answer: B. Stored in a locked container or disabled with a trigger lock, rendering it inaccessible to a minor. In California, when a firearm is not on the person of a CCW permit holder, it must be stored responsibly, especially if a minor could potentially access it. This means the firearm must be kept in a locked container or secured with a trigger lock, making it inaccessible to unauthorized individuals, particularly children. This crucial safety measure prevents accidental shootings and meets legal requirements for safe storage in homes with minors. Always prioritize securing your firearms to prevent tragic accidents. Question 7. A California CCW permit authorizes you to carry a loaded, concealed firearm in your vehicle, provided: A. The firearm is stored in a locked container in the trunk. B. The firearm is unloaded and stored in a locked container, separate from ammunition. C. The firearm is listed on your CCW permit, and you are transporting it in a manner consistent with your permit. D. The firearm is openly displayed on the dashboard for visibility. Answer: C. The firearm is listed on your CCW permit, and you are transporting it in a manner consistent with your permit. A California CCW permit allows its holder to carry a loaded, concealed firearm on their person or within their vehicle, provided that firearm is specifically listed on their valid permit. This is a significant difference from how individuals without a CCW permit must transport firearms, which typically requires them to be unloaded and in a locked container. Always ensure the firearm you are carrying in your vehicle is authorized by your permit and is being transported legally. Question 8. What is a key restriction regarding the firearms listed on a California Concealed Handgun License, CCW? A. You can carry any firearm you own, regardless of whether it's on the permit. B. You can only carry firearms that are specifically listed on your CCW permit. C. You are restricted to carrying only revolvers. D. You can carry any handgun, as long as it's registered in your name. Answer: B. You can only carry firearms that are specifically listed on your CCW permit. A key restriction of a California Concealed Handgun License, CCW, is that you are only authorized to carry the specific firearms that are listed on your permit. During the application process, you must qualify with each firearm you wish to carry, and only those particular firearms will be endorsed on your license. Carrying a firearm not listed on your permit, even if you lawfully own it, constitutes a violation of your permit conditions and state law. Question 9. Following the Bruin decision, what is the primary focus for California issuing authorities when evaluating a CCW applicant, replacing the subjective good cause requirement? A. Demonstrating a specific need for self-defense, such as carrying large sums of money. B. Proving the applicant has no prior arrests or convictions, regardless of severity. C. Assessing the applicant's good moral character and ensuring they meet all statutory requirements. D. Providing letters of recommendation from law enforcement officials. Answer: C. Assessing the applicant's good moral character and ensuring they meet all statutory requirements. After the Bruin Supreme Court decision, California issuing authorities can no longer require applicants to demonstrate a subjective, good cause, or special need for carrying a firearm. Instead, the primary focus has shifted to evaluating an applicant's good moral character and ensuring they meet all other objective statutory requirements, such as training, residency, and not being a prohibited person. This means the issuing authority will conduct a thorough background check and consider aspects of your character and history to determine suitability. Question 10. How often must a California concealed handgun license, CCW, generally be renewed? A. Every 10 years. B. Every 5 years. C. Every 2 years. D. Every year. Answer: C. Every 2 years. A California concealed handgun license, CCW, generally must be renewed every 2 years. This regular renewal process ensures that permit holders continue to meet all eligibility requirements, including maintaining good moral character and completing updated training. It is crucial to be aware of your permit's expiration date and to begin the renewal process well in advance to avoid any lapse in your concealed carry authorization. Question 11. If your California concealed handgun license, CCW, is lost or stolen, what is the required action? A. Notify the issuing authority within 10 days. B. Apply for a new permit immediately. C. Continue carrying without the physical permit until a replacement arrives. D. No action is required unless you are stopped by law enforcement. Answer: A. Notify the issuing authority within 10 days. If your California concealed handgun license, CCW, is lost or stolen, you are legally required to notify the issuing authority, your county sheriff or chief of police, within 10 days. This prompt notification helps prevent potential misuse of your permit and allows the issuing agency to provide you with instructions for obtaining a replacement. Failing to report a lost or stolen permit within the specified timeframe could result in penalties or permit revocation. Question 12. Which of the following individuals is generally prohibited from obtaining a California concealed handgun license, CCW? A. A person who has previously filed for bankruptcy. B. A person convicted of a felony or certain misdemeanor crimes. C. A person who has only lived in California for 1 year. D. A person who has been issued a traffic citation in the past. Answer: B. A person convicted of a felony or certain misdemeanor crimes. Individuals convicted of a felony or certain specified violent or domestic violence-related misdemeanors are legally prohibited from possessing firearms in California, and therefore, cannot obtain a concealed handgun license, CCW. These prohibitions are strict and are designed to prevent firearms from falling into the hands of those deemed a risk to public safety. Always be aware that your criminal history is a significant factor in CCW eligibility. Question 13. Does California recognize concealed carry permits or licenses issued by other states? A. Yes, California has full reciprocity with all other states. B. Yes, but only with neighboring states like Arizona and Nevada. C. No, California does not recognize CCW permits from any other state. D. Only if the permit holder is a resident of California with a valid out-of-state permit. Answer: C. No, California does not recognize CCW permits from any other state. California has some of the strictest gun laws in the nation and does not recognize concealed carry permits or licenses issued by any other state. This means that even if you have a valid CCW permit in another state, it is not valid for carrying a concealed firearm within California. If you wish to carry concealed in California, you must obtain a California-issued CCW permit through the proper local channels. Question 14. When interacting with law enforcement while carrying a concealed firearm with a valid CCW, what should your hands generally be doing? A. Reaching for your firearm to show it is secured. B. Held above your head in plain view. C. Kept visible and still, preferably on the steering wheel or dashboard, unless instructed otherwise. D. Reaching for your CCW permit in your wallet. Answer: C. Kept visible and still, preferably on the steering wheel or dashboard, unless instructed otherwise. When interacting with law enforcement while carrying a concealed firearm, it is paramount to keep your hands visible and still, usually on the steering wheel or dashboard, until the officer gives you specific instructions. This action signals that you are cooperative and minimizes any perceived threat, especially after you have informed the officer you are carrying a firearm. Never make sudden movements or reach for anything, including your permit, without explicit direction from the officer. Question 15. A California Concealed Handgun License, CCW, may be revoked if the holder A. Moves to a different county within California. B. Fails to report a change of address within 10 days. C. Is accused of a misdemeanor crime, even if not convicted. D. Purchases a new firearm not listed on the permit. Answer: B. Fails to report a change of address within 10 days. A California Concealed Handgun License, CCW, can be revoked for various reasons, including failing to report a change of address to the issuing authority within the legally required 10 days. This is because your permit is tied to your residency within the specific jurisdiction of the issuing sheriff or police chief. Keeping your information current is a crucial responsibility of being a permit holder and helps ensure your permit remains valid. Question 16. Carrying a concealed firearm under a California CCW permit is generally prohibited while A. Attending a private gathering at a friend's home. B. Engaging in recreational hiking in a national forest. C. Under the influence of any alcoholic beverage or drug. D. Shopping at a grocery store. Answer: C. Under the influence of any alcoholic beverage or drug. Carrying a concealed firearm while under the influence of any alcoholic beverage or drug is strictly prohibited and extremely dangerous. Impairment compromises your judgment, reaction time, and overall ability to handle a firearm safely and responsibly. This prohibition is a critical safety measure, so never combine alcohol or drugs with carrying a firearm. Question 17. If you are a CCW permit holder in California, how must a firearm listed on your permit be transported in your vehicle? A. It must be unloaded and stored in a locked container, separate from ammunition. B. It can be carried loaded and concealed on your person or readily accessible in the vehicle. C. It must be openly displayed on the passenger seat. D. It must be locked in the trunk. Answer: B. It can be carried loaded and concealed on your person or readily accessible in the vehicle. As a California CCW permit holder, a firearm listed on your permit can be carried loaded and concealed on your person or readily accessible within your vehicle, allowing for immediate access for self-defense if necessary. This privilege is a key benefit of having a CCW permit and differentiates it from the stricter transport laws for non-permit holders. Always ensure your firearm is secured in a holster appropriate for concealed carry to prevent accidental discharge. Question 18. Which of the following is not required for lawful possession of a handgun within your own private residence in California? A. Owning a California Concealed Handgun License, CCW. B. Having the handgun legally registered or otherwise legally acquired. C. Being at least 18 years old. D. Not being a person prohibited from owning firearms. Answer: A. Owning a California Concealed Handgun License, CCW. A California Concealed Handgun License, CCW, is explicitly for carrying a concealed firearm outside your home. You do not need a CCW permit to lawfully possess a handgun within your own private residence, provided the firearm was legally acquired and you are not otherwise prohibited from owning firearms. Your home is generally considered a sanctuary where you have the right to possess firearms for self-defense without a special permit. Question 19. If a CCW permit holder is carrying a permitted firearm, what are the restrictions on the type of ammunition that can be carried? A. Only lead-free ammunition is permitted. B. Only ammunition purchased in California is permitted. C. Ammunition designed to penetrate metal or armor-piercing ammunition is generally prohibited for carry. D. There are no specific restrictions on ammunition type for CCW holders. Answer: C. Ammunition designed to penetrate metal or armor-piercing ammunition is generally prohibited for carry. While there are various laws regarding ammunition sales and possession, California law specifically prohibits the possession of ammunition designed to penetrate metal or armor-piercing ammunition, even for CCW permit holders. These types of specialized rounds are deemed particularly dangerous and are generally restricted from civilian use. Always ensure the ammunition you carry complies with all state and federal regulations to avoid legal complications. Question 20. When renewing a California Concealed Handgun License, CCW, what is typically required? A. Retaking the full 16-hour initial training course. B. Completing a shorter renewal training course, usually 4 to 8 hours. C. Submitting a new, good cause statement. D. A verbal declaration that you still meet the requirements. Answer: B. Completing a shorter renewal training course, usually 4 to 8 hours. When renewing a California Concealed Handgun License, CCW, applicants are typically required to complete a shorter renewal training course, which is usually between 4 and 8 hours. This refresher course ensures permit holders stay current with firearm safety practices, legal updates, and maintain their shooting proficiency. Unlike the initial application, a full 16-hour course is generally not necessary for renewal. Question 21. If a California CCW permit holder permanently moves to a new county, what must they generally do to maintain their CCW privileges? A. The permit automatically transfers to the new county. B. Reapply for a new CCW permit in the new county of residence. C. Simply notify their original issuing agency of the new address. D. They can keep their original permit active indefinitely. Answer: B. Reapply for a new CCW permit in the new county of residence. If a California CCW permit holder permanently moves to a new county, they generally must reapply for a new CCW permit in their new county of residence. CCW permits are issued by the local sheriff or police chief and are tied to the applicant's residency within that specific jurisdiction. A permit from one county is not valid if you are no longer a resident of that county, requiring a new application process with the new local issuing authority. Question 22. Which action by a CCW permit holder would likely be considered illegal brandishing in California? A. Discreetly adjusting a concealed firearm under clothing to ensure comfort. B. Briefly showing a holstered firearm to a friend in a private setting. C. Drawing a firearm from a holster during an argument to intimidate another person, even if no shots are fired. D. Drawing a firearm to defend oneself against an immediate, credible threat of deadly force. Answer: C. Drawing a firearm from a holster during an argument to intimidate another person, even if no shots are fired. Brandishing a firearm, which is generally illegal in California, involves drawing or exhibiting a firearm in an angry or threatening manner, not in self-defense, or to intimidate another person. Drawing a firearm from a holster during an argument to frighten someone, even without firing a shot, clearly falls under this definition and can lead to serious legal consequences. A firearm should only be drawn when there is an immediate and reasonable threat of death or great bodily injury. Question 23. A California CCW permit holder encounters a "No Firearms Allowed" sign posted at the entrance of a privately owned business. What is the legal implication? A. The CCW holder can ignore the sign as their permit supersedes private property rules. B. The CCW holder must immediately notify law enforcement of the sign. C. The CCW holder is legally required to comply with the property owner's prohibition and not carry a firearm on those premises. D. The sign only applies to individuals without a CCW permit. Answer: C. The CCW holder is legally required to comply with the property owner's prohibition and not carry a firearm on those premises. In California, property owners have the right to prohibit firearms on their private property, even if you hold a valid CCW permit, by posting "No Firearms Allowed" signs. Carrying a firearm onto such premises after being notified by a sign or verbal warning can lead to being asked to leave, trespassing charges, or even permit revocation. Always respect private property rights and comply with posted prohibitions. Question 24. For a CCW permit holder, what is the legal status of carrying a loaded firearm in a public place in California? A. It is generally permitted as long as it is concealed and the carrier has a valid CCW permit. B. It is only permitted if the individual is actively engaged in target practice. C. It is illegal under all circumstances, even with a CCW permit. D. It is permitted only if the firearm is openly carried. Answer: A. It is generally permitted as long as it is concealed and the carrier has a valid CCW permit. For a California CCW permit holder, carrying a loaded firearm in a public place is generally permitted, provided it is concealed and the individual possesses a valid and current CCW permit issued by their local authority. This is the primary purpose of the CCW permit, to allow for the lawful, concealed carry of a loaded handgun in public for self-defense. However, this privilege does not extend to sensitive places or private property where firearms are prohibited. Question 25. If a California CCW permit holder wishes to carry a firearm that was not originally listed on their permit, what must they do? A. Simply carry the new firearm, as long as they legally own it. B. Reapply for a new permit listing the new firearm. C. Contact the issuing authority to request an amendment to their existing permit to add the new firearm. D. They are prohibited from ever adding new firearms to their permit. Answer: C. Contact the issuing authority to request an amendment to their existing permit to add the new firearm. If a California CCW permit holder wishes to carry a firearm that was not originally listed on their permit, they must contact their issuing authority to request an amendment to their existing permit. This process typically involves qualifying with the new firearm at an approved training facility and submitting the necessary paperwork and fees. It is crucial to have all firearms you intend to carry explicitly listed on your permit to remain in compliance with state law. Question 26. In the immediate aftermath of a defensive use of force incident involving a firearm, what should a CCW permit holder prioritize after ensuring safety? A. Leaving the scene as quickly as possible. B. Calling an attorney before contacting law enforcement. C. Calling 911 to report the incident, remaining on the scene, and clearly stating they acted in self-defense. D. Removing any evidence that might incriminate them. Answer: C. Calling 911 to report the incident, remaining on the scene, and clearly stating they acted in self-defense. In the immediate aftermath of a defensive use of force, after ensuring the immediate threat is neutralized and the area is safe, a CCW permit holder should prioritize calling 911 to report the incident to law enforcement. It is crucial to remain on the scene, if safe to do so, and clearly inform the dispatcher that you acted in self-defense and potentially have a firearm involved. Providing factual, concise information without excessive detail until an attorney is present is advisable. Question 27. Which of the following firearm modifications or accessories is generally not permitted on a firearm carried with a California CCW permit? A. A laser aiming device. B. A compensator or muzzle brake. C. A drop-in auto sear or any device that converts a semi-automatic to fully automatic fire. D. Night sights. Answer, C. A drop-in, auto-sear or any device that converts a semi-automatic to fully automatic fire. Any device that converts a semi-automatic firearm to fully automatic fire, such as a drop-in, auto-sear, is generally illegal under federal and state law, making it strictly prohibited for use on a firearm carried with a California CCW permit. Such modifications transform a legal firearm into an illegal machine gun. Always ensure your carry firearm is fully compliant with all state and federal regulations to avoid severe legal repercussions. Question 28. What role do mental health records play in the California CCW application process? A. Mental health records are irrelevant to CCW eligibility. B. Applicants must undergo a mandatory psychological evaluation for approval. C. Certain mental health adjudications or commitments can disqualify an applicant from obtaining a CCW. D. Only a history of severe mental illness will disqualify an applicant. Answer, C. Certain mental health adjudications or commitments can disqualify an applicant from obtaining a CCW. Certain mental health adjudications, such as being found a danger to oneself or others, or involuntary commitments to a mental health facility, can disqualify an applicant from obtaining a California CCW permit. These prohibitions are in place to ensure that firearms are not accessible to individuals who may pose a risk due to mental health issues. Issuing authorities conduct thorough background checks, which include reviewing relevant mental health records. Question 29. The use of force continuum, in self-defense, when applied to firearm use, generally suggests A. Always drawing and firing your firearm as a first response to any threat. B. Responding with the minimum amount of force necessary to neutralize a threat, escalating only when justified by the threat level. C. Using lethal force for any perceived threat to property. D. That a firearm should only be used after all other physical confrontations have failed. Answer, B. Responding with the minimum amount of force necessary to neutralize a threat, escalating only when justified by the threat level. The use of force continuum is a guiding principle in self-defense, emphasizing that one should respond with the minimum amount of force necessary to neutralize a threat, escalating only when the threat level justly demands it. When it comes to firearms, this means lethal force should be considered a last resort, used only when there is an immediate, credible threat of death or great bodily injury. Always remember to assess the situation and use only proportionate force. Question 30. Carrying a concealed firearm is prohibited in all of the following sensitive places, under California law, except A. Any K-12 school campus or facility. B. Within 1,000 feet of a K-12 school. C. A polling place while an election is underway. D. Inside a private residence with the owner's permission. Answer, D. Inside a private residence with the owner's permission. While California law designates many places as sensitive, where concealed carry is prohibited, carrying inside a private residence with the owner's permission is generally not among these restricted areas. The sensitive places restrictions primarily apply to public or semi-public locations like schools, government buildings, and polling places. Your right to carry in a private home depends on the homeowner's consent. Question 31. A California CCW permit holder goes to a restaurant that serves alcohol. What are the rules regarding carrying a concealed firearm there? A. Carrying is prohibited in any establishment that serves alcohol, including restaurants. B. Carrying is generally permitted in restaurants, but prohibited in bars or bar areas. C. Carrying is permitted as long as the CCW holder does not consume any alcohol. D. The rules depend on whether the restaurant displays a "No Firearms" sign. Answer, B. Carrying is generally permitted in restaurants, but prohibited in bars or bar areas. In California, A CCW permit generally allows you to carry a concealed firearm in a restaurant that serves alcohol, but it is typically prohibited in establishments or areas primarily devoted to the sale and consumption of alcohol, such as bars or the bar sections of restaurants. The distinction often hinges on whether food is the primary business, or if it is primarily an establishment where alcohol is consumed. Always err on the side of caution and avoid carrying in any place where alcohol is the main focus. Question 32. What is the general rule regarding carrying a concealed firearm with a CCW permit near a K-12 school in California? A. Carrying is permitted as long as you are not on school property. B. Carrying is prohibited within 1,000 feet of a K-12 school, unless certain exceptions apply. C. Carrying is permitted if you are picking up or dropping off a child. D. There are no specific restrictions for CCW holders near schools. Answer: B. Carrying is prohibited within 1,000 feet of a K-12 school, unless certain exceptions apply. In California, carrying a concealed firearm, even with a CCW permit, is generally prohibited within 1,000 feet of a K-12 school campus or facilities. This is often referred to as a gun-free school zone. While there are specific exceptions, such as for authorized law enforcement, permit holders should be very aware of these boundaries to avoid violating the law. Always be mindful of school zones when carrying. Question 33. Carrying a concealed firearm with a California CCW permit is generally prohibited on what type of property? A. Privately owned vacant land. B. Federal property, such as a post office or national park visitor center. C. A public sidewalk adjacent to a non-sensitive building. D. A privately owned parking lot. Answer: B. Federal property, such expansionist post office or national park visitor center. Carrying a concealed firearm, even with a California CCW permit, is generally prohibited on federal property, which includes places like post offices, courthouses, and national park visitor centers. Federal laws often override state concealed carry permits on such properties, making it illegal to carry a firearm. Always be vigilant about identifying federal facilities and avoid carrying your firearm into them. Question 34. What are the potential consequences if a California CCW permit holder is found to be carrying a firearm while intoxicated? A. A minor citation and a warning. B. Automatic revocation of the CCW permit and potential criminal charges. C. A temporary suspension of the permit until sobriety is confirmed. D. No consequences, as long as the firearm remains concealed. Answer: B. Automatic revocation of the CCW permit and potential criminal charges. Carrying a firearm while intoxicated is an extremely serious offense in California and can lead to severe consequences, including the automatic revocation of your CCW permit and potential criminal charges. Intoxication significantly impairs judgment and motor skills, creating a dangerous situation for the permit holder and the public. Never carry a firearm if you are under the influence of alcohol or drugs. Question 35. Under California law, when is a handgun considered loaded? A. When it is in a holster. B. When there is an unexpended cartridge or shell in the firing chamber or in an attached magazine. C. When the magazine is inserted, regardless of whether a round is chambered. D. Only when a round is physically in the chamber. Answer: B. When there is an unexpended cartridge or shell in the firing chamber or in an attached magazine. Under California law, a handgun is considered loaded when there is an unexpended cartridge or shell in the firing chamber or in an attached magazine. This broad definition means a firearm with a loaded magazine inserted, even if a round is not actively chambered, is generally considered loaded. Understanding this definition is critical for all firearm owners, especially CCW holders, to comply with carry and transport laws. Question 36. What is the primary purpose of a proper holster for a concealed carry firearm? A. To make the firearm difficult to draw quickly. B. To show off the firearm's appearance. C. To securely retain the firearm, protect the trigger guard, and allow for a safe, consistent draw. D. To keep the firearm separate from ammunition. Answer: C. To securely retain the firearm, protect the trigger guard, and allow for a safe, consistent draw. The primary purpose of a proper holster for a concealed carry firearm is to securely retain the firearm, completely protect the trigger guard from accidental contact, and allow for a safe, consistent, and efficient draw. A good holster prevents accidental discharges, keeps the firearm from shifting or falling out, and ensures you can access it reliably when needed. Always invest in a high-quality holster specific to your firearm. Question 37. To justify the use of deadly force in self-defense, a CCW permit holder must generally believe that the threat is A. Annoying or disrespectful. B. Capable of causing minor injury. C. Immediate and capable of causing death or great bodily injury. D. Only a verbal threat that makes them feel uncomfortable. Answer: C. Immediate and capable of causing death or great bodily injury. To legally justify the use of deadly force in self-defense, a California CCW permit holder must have a reasonable belief that the threat is immediate and capable of causing death or great bodily injury to themselves or another innocent person. This means the danger must be happening right now, not a future or past threat. The standard is high because deadly force is irreversible and should only be used in dire circumstances. Question 38. If a CCW permit holder uses their firearm in self-defense, which of the following is crucial immediately after the incident? A. Leaving the scene to avoid further confrontation. B. Waiting for an attorney to arrive before calling 911. C. Remaining on the scene, securing the firearm if safe, and cooperating with law enforcement while limiting initial statements to essential facts. D. Discussing the incident in detail with witnesses. Answer: C. Remaining on the scene, securing the firearm if safe, and cooperating with law enforcement while limiting initial statements to essential facts. After using a firearm in self-defense, it is crucial for a CCW permit holder to remain on the scene, if safe to do so, secure their firearm, and immediately call 911 to report the incident. When law enforcement arrives, cooperate fully by stating essential facts like, "I was in fear for my life and acted in self-defense," and identifying yourself as the permit holder, but avoid making detailed statements until you have consulted with an attorney. Your priority is to ensure your safety and comply with authorities. Question 39. A person who has been convicted of a misdemeanor crime of domestic violence is A. Eligible for a California CCW permit after 5 years. B. Permanently prohibited from possessing firearms under federal law. C. Prohibited from carrying concealed, but can open carry. D. Required to complete additional training to obtain a CCW. Answer: B. Permanently prohibited from possessing firearms under federal law. Under federal law, a person convicted of a misdemeanor crime of domestic violence is permanently prohibited from possessing firearms. This is a crucial disqualifier for obtaining a California CCW permit and for firearm ownership in general. This federal prohibition, often referred to as the Lautenberg Amendment, is designed to prevent individuals with a history of domestic violence from accessing firearms. Question 40. According to recent California legislative updates, e.g., in 2025, which of the following locations is now typically considered a sensitive place where concealed carry is prohibited, even for CCW holders? A. A private club with a membership fee. B. A public park or public playground. C. A private home with an invite. D. A retail store that sells general merchandise. Answer: B. A public park or public playground. Recent California legislative updates, particularly those taking effect in 2025, have significantly expanded the list of sensitive places where concealed carry is prohibited, even for valid CCW permit holders. Public parks and public playgrounds are now typically included among these restricted locations. It's essential for all permit holders to stay informed about these evolving laws to ensure full compliance and avoid legal issues.